application and appeal in the matter of AstraZeneca AB and Glenmark Pharmaceuticals Europe Ltd.
Yes.
Good morning, my lords. As my lords will have seen from the skeleton, I appear with Mr. Lunt on behalf of the appellants. AstraZeneca, instructed by Freshfields. My learned friend, Mr. Abrams, King's Counsel, appears on behalf of the respondent. Glenmark, instructed by Appellant Gilbert. Before I start, my lords will have seen there is material that's marked both confidential and highly confidential, subject to my lords. My learned friend and I are agreed that the 3122 order that was ordered by my Lord Justice Arnold at the last hearing, the permission hearing, should continue pro tem.
That's very helpful. Thank you very much.
My lords, if I may, I will start with a little bit of background before going on to ground one.
Yes, I mean, you can take it that we've read the papers, in my case, certainly not all of the authorities, but one or two of them. So I think we have a lively appreciation of the background and the material issues for today, but do please take your own course. We have today, we're relatively confident you won't have any difficulty in finishing today, but within that, both of you, please just take your own course. We won't be policing you.
I understand, but
unless, of course, we get to lunchtime and it looks as if you're halfway through, in which case I might get a bit feisty. But other than that, it's over to you.
Well, my lord, to give my lords a heads up in terms of sort of timing and pace, I have a little background section. I don't think, given my lord's very helpful indication about reading, that will not take very long. It's really to highlight why we're here and some key points which we say flow through all the grounds. I then have a rather longer section on ground one because I do need to take my lords both to the law and also to why what I say the law is makes a difference to the findings of fact. Ground two is somewhat faster, and ground three I think will take comparatively little time at the end. So my lords will have seen that this case follows what is now a well-trodden route in the Patents Court. The originator, in this case AZ, want to protect a long-standing monopoly in relation to a valuable drug. That monopoly will continue unless the patent and its associated SPC is invalidated until 2028. And my lords will have seen from the paper it's a very valuable monopoly indeed. Obviously, generic drug manufacturers want, if they can, to sell their generic infringing drug. To be able to do that, they need to invalidate the patent. And as my lords will have seen, separate from this application, but involving Glenmark and two other parties, Teva and what is now Viatris, but was previously is effectively associated with Generics UK and Mylan, launched an action to invalidate the relevant patents, SPCs. That was heard by the judge who heard this application, Dr. Tappin, King's Counsel, between the 10th and the 20th of March this year. And as my lords will have seen, the judgment in that matter is pending. And what the judge agreed with the position taken by the parties, that it is likely that the form of order hearing in that judgment will take place sometime between 1 and 3 months from the 17th of March. And that's in the judgment of J27. As my lords will have keenly appreciated by now, AstraZeneca are here because they say that Glenmark, having kept quiet from the CMC in January 24, when they sought a trial in January 25, have launched without warning and effectively are jumping the gun in relation to judgment. And as we've seen, AstraZeneca were informed of this on the night of the 20th of February, and then as is recorded at the beginning of the judgment, we came on for the hearing on the 27th shortly thereafter. Now, again, as I'm sure my lords will have appreciated, the whole point of AstraZeneca's application is to preserve the status quo in that the short period between today, when, as matters stand, there are no generics on the market, and the form of order hearing after Dr. Tappin's judgment in the validity action. And that is because, for the very obvious reason in my submission, AstraZeneca accept that following judgment, the status quo necessarily may have changed. There are two sets of key factors that may have changed. One is, of course, what the judge finds in relation to the patent. Does he find it valid? Does he find it invalid? If so, on what basis? And is permission given? And also at that stage, one can realistically expect that other generics other than Glenmark will be at the form of order hearing, certainly the two that are involved in the validity case, possibly others, and they will have something to say about what happens next. And in particular, if permission to appeal is given, whether there is a stay of any injunction or not, or injunction is ordered pending the conclusion of the appeal. Now, a very important step, as my lords will have seen in the learned judgment's judgment in this application, this is at J27 and 28, sorry, J being a reference to the judgment paragraphs. He accepted that it's impossible to predict what the state of affairs at the form of order hearing will be. And in my respectful submission, he was absolutely right to do. One can't prejudge either his judgment or any of the questions that the court will need to consider following that judgment. The judge also found, and this is very important in my submission, and it underpins both ground 1 and ground 2, that the question he had to look at was whether or the damage that would be caused by either granting or not granting the interim injunction AstraZeneca cease, sought, obviously, and he also found, and this is a judgment para 31, that that damage might manifest itself either between now and the formal order hearing, or it might manifest itself after the formal order hearing. And that's a point I will come back to in particular with the way the judge looked at what was going to happen at the formal order hearing. The central point I want to develop, and I will start, and it really flows through both grounds 1 and grounds 2, that if the American Cyanamid test is applied correctly, both as to adequacy of damage and as to balance of convenience, then AstraZeneca is entitled to prevent the market becoming partially or wholly generic before the formal order hearing. And that's as far as I need to go in terms of today in my respectful submission. And what I wish to develop in front of my lords is to say, with the greatest respect to the learned judge, he misapplied American Cyanamid, and that's why I will go through on ground 1 the way on high authority that test is explained and developed, because he lost sight of the importance of uncertainty at this stage. Instead, he reached for certainty in the decision over adequacy of damages when we say he shouldn't have done, and likewise in the balance of convenience. I also say, which is ground 2, that he failed to follow his own direction, that he needed to consider, amongst other things, the question of whether the losses suffered by AstraZeneca at or after the form of order hearing were capable of being adequately remedied in damages. And I say he lost sight of that. And the primary point he lost sight of that in my submission, I will develop this as I go forward, is he appears to have considered only the situation where an injunction would be granted at the form of order hearing. And that's the origin in my submission of the statements that say everything can come back to normal. And in my submission, when one looks at the different options available to the court at the form of order hearing, that is just one of them. There are many others, and I'll develop that one. And the last point, if I may, is ground 3. We say that the assessment of damage to Glenmark is wrong for reasons that I will go on to express.
You haven't mentioned ground 4.
My lord, I don't think I need, well, subject to my lord, the position I have to do is to convince my lords that there has been an error suitable of intervention by my lord's court. If that is the case, then in my submission, my lord, I am entitled to rely, and I don't think my learned friend pushes against this, on a normal lad and marshal basis on the evidence that's in Stothers 4, and that merely brings the court up to date with what has actually happened since Dr. Tappin's judgment. I'm not, I think, although it is in ground 4, running a separate point of that in and of itself is a reason for my lords to intervene.
No, but as I understand it, the relevance of the new evidence you say is that this court now knows that what at the time of the hearing before the judge appeared merely to be a real risk is now, you say, a certainty.
My lord, yes.
And that inevitably affects the assessment.
Of course, yeah, exactly.
Adequacy of damage.
Exactly so, my lord. I also say it illustrates the point that AstraZeneca sought to advance in front of the learned judge, is that one really, when one's looking at the from the point of view he was standing at, one cannot assume, one can't find a sort of gradated finding that it is likely that the generics will enter in 6 to 8 weeks. It's too uncertain in these circumstances, and the possibility that's now become a certainty was always a possibility you ought to have in mind. So that illustrates the uncertainty point in my submission that I will develop in ground one. But I should say I respectfully entirely agree with what my lord has put to me on the general point about what was previously a risk is now a certainty. And just
That's a convenient question to address, the juncture at which to address the prior question, which is, have you discussed with Mr. Abrams whether he's opposing the new evidence coming in?
I didn't understand from his skeleton he was. I will ask. Are you opposed to it, James?
We don't think that it undermines the judge's judgment at all, and therefore there's no, it's not helpful for us to take a prior procedural point and have to.
Right, so you're content for the new evidence to come. Thank you.
My lord, I can, if my lords wish, I can develop the point on Loudon Marshall, but I think my submission.
We don't need to.
We don't need to. I'm very grateful, my lords. And it might be a convenient well, actually, I'll come on to it in a minute. In a few minutes, I will update my lords to what we say that evidence now shows is a certainty in relation to both generic entry and at least gives us a better picture, well, gives us a very good picture of the rate of entry, which I'm going to submit is effectively immediate, and also gives us a very good indication of the size of entry, which I'm going to submit is very large indeed, and also in my submission, and I'll make this good later, gives the lie to the idea that any one generic, Glenmark being one, but generics X and generic Y is named in the skeleton, by the way, generic X is not, have first mover advantage, because the reality is at this stage there are 3 very large players all putting on all ready to put on at least 20% of a month's supply effectively immediately, and that is exactly the sort of situation that gives rise to a price spiral and very rapid and unquantifiable loss. But I need to develop that point as I go, if I may. Sorry, did my Lord Justice Coulson have a question?
No.
Oh,
no.
I'm so sorry. So 4 preliminary matters, and the first matter, I suspect, is one that my Lord Justice Arnold will not need any background on, but I think I should put to the court, which is just to quickly run through the differences between pricing, list pricing, and the VPAG. I then want to very quickly look at the market for dapagliflozin, and my point for looking for that is to urge on the court that it is an unstable market, and the reason for illustrating that, and this is the point that was run clearly in front of the judge, though he doesn't deal with it in any detail, is that there is a difference between an unstable growing market and a stable market. I then do want to spend a little bit of time on explaining what Glenmark's primary case was before the judge, and it will be apparent by now that their primary case was they were going to be the only generic game in town. Now, that wasn't their only case, before Mr. Abrams corrects me. They had a case run on multiple generic entry, but it's no question their primary case was based on that. And I want to explore that a little bit, and then I will briefly go through the points in relation to the generic entry that are in Stollers 4. On pricing, if my lords have the points that I am putting now, I will move on. So I will be grateful for an indication. But I want to deal with first the, and I'm picking this up from my learned friend's evidence from Mr. Farrant, in international non-proprietary name on the prescription for the drug means that the wholesalers can prescribe any drug, and in this case the evidence was 90% of prescriptions are marked in, and that's in Farrant 1, 25 and 26. Reimbursement. So the way this works, this drug is going to market via the producer to a wholesaler to the pharmacist to the public. The pharmacist buys the drug effectively from the wholesaler who's bought it from the producer, and the pharmacist gets paid back by the NHS at a reference price, which is generally the drug list price, and that's, for my lord's reference in the evidence, is Farrant 134. As my lords will have seen, the NHS can choose what the reimbursement price is, There's the category A, which is the category that my client's drug is in now, which is when there is no generic on the market. There is category C, my line friend correctly, is category C when there's no generic on the market. Category A, where there is a relatively small number of generics on the market. In that case, that price becomes, instead of the list price, a weighted average of the largest generic suppliers. And category M, which is the situation when the market is very full of many different generic suppliers, and that's a weighted average of all the suppliers. And again, for that, I go to Farrant 1, para 36. And as my lords will have seen, the NHS controls the movement, or rather the DHSC, which is a branch of the NHS, controls the movement between the different tariffs. So unless and until the NHS decides to change the categorization from category C, that is the price the pharmacist will receive for every drug they sell, whether it is an AZ drug or if they come on the market, whether it is a generic. And as my lords will, I'm sure, gather very quickly, it is therefore highly beneficial for the pharmacists and indeed the wholesalers to obtain generic drug at the lowest price they can, because they make a profit or additional profit on the delta between the list price and the reimbursement, between the reimbursement price, the list price, and the price they actually buy at. And this is, in my submission, the origin of the price spiral. There is a keen market of wholesalers who are out trying to get the best possible price for a drug such as this, and that is why there is a tendency when generic drug is available to buy effectively what is the cheapest available, because this is a white pill. This is not a specialized drug like a biologic where you've got a limited number of suppliers. Effectively, one pill is as good as any other pill. It is just a question of price. Selling price versus list price, which is the second to last point I have on this. Common ground, and this is in Farrant para 51, that originators can lower their selling price to wholesalers, and that's wholly unsurprising. And I just mention that because there is a difference, and I'll come on to this when I looked at Mr. Farrant's evidence, between Mr. Farrant's consideration of list price, which is a theoretical number in the NHS, that the effectively tells the NHS what they're going to pay back to the pharmacist, and the selling price, which is the price that the wholesaler stroke pharmacist actually pays. Very last point on this, which I can take very quickly. My lords will have seen a reference to VPAG. That is a voluntary reimbursement scheme given by originators such as the NHS given by originators to the NHS. It's explained in the footnote 2 to Mr. Farrant 1. And the evidence in this case, which comes from Glenmark's Mr. Oliver, which I agree with, this is public, AstraZeneca reimbursed 22.9% of their list price to the NHS. And the relevance of that I'll come to when I look at the damage of the NHS right at the end of these submissions. The next point, unless my lords have any questions on that, is to take very quickly the market for dapagliflozin. And if I could refer my lords to our skeleton, and particularly to paragraphs 2 to 5. Our skeleton is in tab 4 of the core bundle. And as my lords have read this, I won't spend much time on this. The graphs, in a sense, speak for themselves. Dapagliflozin, like all, as I understand it, I might be correct if I'm wrong, all glyphosins is what's called an SGLT2 inhibitor. The graph on the left shows the relative market share.
Sorry, just give me the paragraph again.
I'm so sorry, my lord. So it's in our skeleton.
Yeah.
I'm looking at the section between paragraph 2 and paragraph 5.
Oh, sorry.
I'm so sorry. My lord will know, my
Yeah,
lord's there.
yeah.
I've got a paragraph 4. There's a
Yeah, so you're looking at the graphs. Yeah.
looking at the graphs. And the one on the left shows how the market share for this kind of drug, an SGLT2 inhibitor, has varied. And the point there is there are basically 3 players in the market, of which dapagliflozin, which is the drug in question here, is but one. There has been a lot of variation over time. And the second graph, one sees to the right, Forxiga is the name of the primary drug of dapagliflozin that my client sells. There has been a very rapid increase in the market. And the point, and I don't think I need to go through these paragraphs, I think they speak for themselves, is that we say this is not a stable market. I'll come on in a minute. My Lord Justice Arnold, in a case called Warner Lambert and ICOS, looked at a stable market. That was a market, it's actually in the bundle, I don't need to go to it, but at tab 7, page 160, paragraph 117, and the quote there is, the market is flat, settled both in value and quantity of packs. Sales were about 18 million over the last 2 years. Now that is a stable market. Dapagliflozin in my submission is not a stable market. So what I mean by that is it is clearly growing, it is clearly variable, and therefore if things can vary, such as generic entry, which may have a profound effect on what happens to the size of the market, and they're very hard to predict. So taking those points, if I may, in turn, 'cause I've slightly skipped over them, we say it's varied over time. One can't predict in the future, at least with the evidence before the court, what the other dapagliflozins are going to do. There's been very rapid growth since 2022. And the last point, which is a point that comes out, is referenced properly in the skeleton from Dr. McGill, who is AstraZeneca's witness evidence, is there's a potentially very large market of additional people who may benefit from glyphosins, up to 3.7 million extra people. Whether those people end up on dapagliflozin or not is obviously a matter that is affected to a large extent by the way AstraZeneca is able to promote that drug, and that obviously depends to a large degree on whether the drug is generic or whether they still have a monopoly. My penultimate point before getting on to ground one is just to emphasise how things have changed since 10:30 on the morning of the hearing in front of Dr. Tappin. And my lords will have seen that what was argued, and I won't go to it, but one can see it from their skeleton in front of Dr. Tappin, which is supplemental 21 and para 25. They fought, unsurprisingly, tooth and nail to say there was only one generic that was going to come into the market before the form of order hearing, and that generic was Glenmark. And there is a lot of evidence from their Mr. Meanwell, but also from their expert, Mr. Farrant, that goes to say that must be right. They're the only one who prepared to take the risk, and there was no motivation for anyone else. Now, that was firmly rejected by the judge in paragraph 58 of the judgment before we knew about generic X and Y. And it's important, the reason I'm going to this point now is that that underlying assumption sits behind the heart of some very important parts of Glenmark's case, and in particular sits behind the heart of its first mover advantage case. I'll explain why as we go forward. And my lords will have seen that the learned judge below and accepted Glenmark's submission that there was a material first mover advantage. Now it makes that effectively is saying if we get there first, if we get our deals with the wholesalers first, if we're on the market first, then we are in a better position than everyone who comes second, third, or fourth. Of course, that now is not the position, because we know, and I'll come on to it in the next section where I look at the Solvers 4 evidence, that there is no effective first mover to all intents and purposes. And one can see this particularly by the way there have been negotiations about undertakings. Everybody wants to have 175,140 packs sitting with the wholesalers waiting for my lord's decision in this appeal. And the reason they all three of them want them at the wholesaler is they want to have no delay whatsoever. Effectively, they can pick up the phone in my submission, make a call, and release those drugs to market, effectively sell them, release them to market. So the idea that was really behind the whole of the Glenmark argument, the heart of the Glenmark argument, the first mover advantage, the Glenmark exceptionism, if I can put it that way, A, it was rejected by the judge, and B, it is entirely blown out of the water, and it's blown out of the water in a way in my submission when I come back to the final ground that shows that there is it is illusory to think there is any first mover advantage whatsoever now. And just to make that point good in terms of the new evidence in Stothers 4, one of sorry, my lord, just one of the complaints AstraZeneca had of Glenmark in front of the learned judge below was that Glenmark were entirely tight-lipped about the quantity of drug they wanted to put on the market. And obviously, that is a very important point, because if one is looking at the way the market reacts economically and the rate at which there might be a price spiral, it makes a huge difference whether one's putting on 1% of the market in one town in northeast England, or one is putting on, as we now know the case is, at least 20% of the market. Now, we know that because in the hearing in front of my Lord Justice Arnold, there was a discussion, and it's recorded in my Lord Justice Arnold's order at tab 10, as to whether or not Glenmark should be allowed to keep 175,000 change packs at its wholesalers. Now, we don't know, because Glenmark haven't told us whether they have more than that, but we know that there are at least, as of today, 175,140 packs sitting in the wholesalers, good to go. That's...
To be clear,
I'm sorry, my lord.
Benefit of those who weren't present and therefore don't know, Mr. Abrahams informed me that his client had, at that moment, 175,000 packs in lorries ready to go to wholesalers.
I'm sorry.
His point was that his client, whatever else, at minimum, he argued for more, but his proposition was that at minimum, they should be allowed to make the physical distribution of the packs sitting in the lorries to the wholesalers. And that is what has transpired.
My lord, yes, and I wasn't. This wasn't by some kind of collateral complaint about that. It's merely reporting the fact that we now know that to be the case. I'm very grateful for my lord's much clearer exposition of where we are. What we know from Stothers 4, paragraph 14a, is that 175,000 packs is approximately 20% of 1 month's supply of this drug. I'll come back to that in a minute. We also know from Stothers 4, and I don't think I need to turn it up, but there are 2 other generics. One is named, I will refer to that one as generic Y, because there is a question about whether that is public. My lords can know the name of it, but there is still an active debate. The other one wants to stay entirely anonymous and is generic X. What we know in my submission from generic Y, there was a letter, and the letter was shown to my Lord Justice Arnold, as it is at tab 19 of the supplementary bundle, is that generic Y, paragraph 3.
Is the identity of Y conceivably secret? Anybody who was in court on 31st of March will be able to put 2 and 2 together and work it out.
My lord, I would respectfully say my lord's entirely right. I am merely cautious because I am not counsel for Y, and it's not really in my gift as opposed to the courts to say that. So certainly I would entirely agree respectfully with my lord that it does not take any amount of intellect to work out A, who the likely characters are, and B, in this case, because of what was said, who generic Y is. I'm happy to refer to generic Y by its name if the court wishes me to.
Mr. Abrahams, do you have any views on this question?
I agree with your lordship. I'm sure everybody in court knows who generic Y is.
Yeah.
So the only notice part behind is that generic Y have complained to my solicitors that it shouldn't be referred to in public, but that's the origin of my caution, but it's a matter for my lord.
Well, I don't think I appreciate we need to take into account their interests as well as the interests of the parties who are presently before the court. However, their solicitors wrote a letter which they agreed could be shown to the court, and it was referred to in open court. And in those circumstances, I can't think that there's any secrecy in the matter.
My lord,
as far as the identity of Y is concerned.
I'm very grateful, my lord.
And of course, As you know why, it's obvious anyway, because they're one of the litigants in the revocation proceeding.
Precisely so, my lord. They are also about the largest, sorry, generic Y, as my other lords already know, are Teva. They are, of course, one of the largest, if not the largest generic, and they have form with early launch in, for example, things like atorvastatin. So, as my Lord Justice Arnold said in my respectful submission, one should be not unsurprised at all that their position is that they are ready for an immediate launch. Their letter says, I don't think I need to turn it up, it's on the last but two paragraph on the page. They want to launch immediately because they want to preserve first mover advantage. In other words, they want to launch to prevent Glenmark having first mover advantage. There are discussions ongoing to hold the ring. Neither Teva nor generic X have come on the market. There are discussions about undertakings. I don't need to go into those, probably shouldn't because there are discussions, but I can say this to the court. Unsurprisingly, Teva wish to have permission for 175,140 packs on the lorries to wholesalers in exactly the same way that Glenmark did. And that is reflected in exactly the same position with generic X. One sees that from Stodders 14A. Generic X also want 175,140 packs. So that
There's no magic in that figure, except that was the figure that happened to be on the lorries at the time before the hearing before my lord.
In relation to Glenmark, that must be right, my lord. And in relation to
It's not some special intellectual property figure.
The 140.
I'm just anxious to understand the runes here, but so it's completely accidental. That happens to be the number
Yes, the
that Glenmark has.
Yes. Yeah. And so what has happened in my submission, my lord, is that the other generic suppliers having.
I do apologise for interrupting. As I said, we're not objecting to Stodders 4. My friend is starting to give evidence of matters that aren't even hinted at in Stodders 4, and obviously we do object to him giving evidence orally today.
Yeah.
I just put on mark. I don't need to ask you to make a ruling, but I'm just making sure that that's clear.
I mean, I felt it was my duty to update the court as to what has been said by the other generics. That I can obviously give an undertaking from those behind me to update the court as to the position in relation to the undertakings. But even, I mean, my position, which I will have to make good against my lone friend's objection, is that we now have 3 generic companies, all of which are saying they have at least 20% of a month's supply ready to go. That's the inference in my submission that can be drawn from that evidence. If I'm not allowed to rely on the 20% figures for the other 2, then I rely on the fact that Teva are more than capable of launching in large quantities immediately, and they have said they wish to do so, and that is to be inferred as the same position for generic Y. And that's not in 6 to 8 weeks' time, the figure that's referred to in the judgment. That is, as Teva say, immediate. And in my submission, there are 3 clear inferences that can be drawn from this new information. The first is the market will be effectively generic, or at least very seriously generic, by the form of order hearing. That is merely a factor of having these kinds of quantities of drug put on the market by 3 competing players at about the same time. Second point one gets from this is, in my submission, there will be a price drop because they're all trying to grab their market share as soon as possible. That's why Teva refer to first mover advantage. They want to get in there and grab their market share. My submission. So the price will drop as they scrabble to do that. And the final point, which I've already made, so I won't repeat, is the idea that any one of them has a material first mover advantage is, in my submission now, illusory. This is a commodity market, effectively now, where the players are who would have launched, but for Glenmark's launch, would have launched presumably after judgment, now want to get on the market to prevent Glenmark getting any advantage at all. So, last point before turning on to ground 1, just an overview of this appeal. Now, self-evidently, and this is my learned friend's, as I understand it, main point, each case of this nature turns on its facts, but there are a few in my submission background facts, which I pray and aid generally and will make good, as to why we respectfully submit the learned judgment, the learned judge, despite looking at this carefully, went wrong. And the first is that in this jurisdiction, the courts have readily accepted that where multiple generics enter the market, then there will be a price spiral downwards, and that leads to unquantifiable loss. Now, that's not a rule of law, self-evidently, but it is, in my submission, an important piece of background. And that is why, of course, the parties in front of Dr. Tappin were having such a ding-dong in relation to whether it's just Glenmark entry or whether it's multiple. That's why it was such a big factual issue. Now, against this, my learned friend, and he goes to the Terrell quote, which I don't need to, the unquantifiability only arises if the price depression is permanent. Now, that's not quite right. When one looks at the cases as well, if there's a risk of a permanent price depression. I'll come back to that a little later and explain why my learned friend's point doesn't work. This key point, which I've already raised, is we say the judge, despite the care he took, lost sight by only looking at one option at the form of order hearing, and that is that there was going to be, in effect, an injunction, and therefore, because the list price on his finding wouldn't go down, the prices would go back up, there would be no loss to AstraZeneca. That loses sight of the myriad of other options. We also say the judge lost sight of the non-pecuniary loss, that if AstraZeneca's price does go down and it has to be negotiated back up again, then AstraZeneca will have to work hard to do that, and that is effectively the loss of goodwill that's discussed in various cases such as SKB and Apotex. I'll come to that. And that's the high degree of resistance that's referred to by Dr. McGill in her evidence at para 55. And I also will develop...
On that,
sorry.
I mean, you quoted passage from the judgment I gave at first instance quite some time ago, in which I observed that there was no evidence at that point in time of any case in which an interim injunction having been refused and prices having therefore been cut by the originator, after trial the originator having succeeded, the originator was able to raise its prices back up to where they were before. Yes. Now, help me on that. The question, does the evidence in this case provide any update on that? In other words, do we yet have an example of an originator who has been able to restore its prices fully to where they were?
Can I? My understanding is no, but can I double check that, my lord, to make sure I don't misinform the court? Are those behind that? I think the answer to that is no in this kind of situation, certainly. And I will come on to the cases in due course. They are referred to in our statement, and I won't spend very long on them, where an interim injunction has been refused. Those are all very, very different facts from the facts we're considering today. I made a mistake. I said that was the last point before ground one. The last point before ground one, I do want to raise two policy issues, and I need to run these.
So you want to raise
two policy issues. I want to be clear, I'm not raising these in a hand-waving sense if that means the answer is wrong. I will tie them to the grounds in American Cyanamid to show why they are relevant considerations when looking at American Cyanamid. And the two policy issues in my submission are these. First is what we have in this case is a disorderly launch very close to judgment. Dr. Tappin is doubtless beavering away on a judgment, and but for the fact that Glenmark had launched, Teva and generic X would not be launching. That amount, I think, is a fair inference. And that, if this kind of case becomes common, then there is a real risk of regular disorderly launches before judgments of this nature. There is nothing in my submission particularly special about this case. This isn't a case where there is a stable market, only one conceivable generic. This is a normal white pill multiple generic entry case. And in my submission, there is a public policy point that it's not conducive to the orderly disposal of these matters to have this kind of launch on regular intervals is potentially a huge burden on the court. It is also a huge burden on a party such as AstraZeneca, who legitimately, I can't go far on this because the judge didn't entirely agree with it, but it is nonetheless the case that AstraZeneca were in the middle of trial preparations and into trial as this came on. It is a huge disruption. And the answer to that in my submission, so that's discussed in paragraph 18 of our skeleton, goes all the way back to the judgments of Mr. Justice Jacob, as he then was in SKB and Apotex, and later by Lord Justice Alderson at Apotex, is that there is the concept of clearing the way. In other words, making sure that before you launch, you have disposed of any validity issues, I suppose infringement issues, but primarily the validity issues before the patent. And I said I'd make this good in the context of American Cyanamid. I submit that this is primarily engaged in three ways. First, if one thinks about it, it puts a very large burden on a party such as AstraZeneca to deal with a case where it is trying to give evidence about what third parties, large third-party generics are likely to do, and then evidence about what it's going to do on a counterfactual that is very, very hard to predict. And those evidential difficulties are caused in my submission by the disorderly entry. The only reason we have to guess what Teva and generic X and the various other generics are doing is because Glenmark have effectively shanghaied, sorry, I should put it more politely, have decided to launch in this manner. I should put it less pejoratively. The second point is, and it relates to ground 1 and ground 2, it distorts the status quo in relation to the proper time for it to be considered, which is my submission, is after the learned judge has given his judgment in a month's time. The final point, and this does go to our ground 1B, which is a different route to the same answer. I will show my lords in a minute. My lords will doubtless be very familiar with them, but when one looks at American Cyanamid, one looks at Factortame, one looks at National Bank Jamaica, special factors were there at the beginning, they haven't gone away. And in my submission, maintenance of the status quo this close to judgment is a special factor that may weigh heavily in the court's decision on the application of section 37. Now that was a rather long introduction to take me to ground 1, if I may, unless my lords have any questions on everything I've said so far. So what I'd like to do first, so as my lords will have seen, ground 1 relates to the correct approach in my respectful submission of the principles set out by Lord Diplock in American Cyanamid. And what that goes to, in my submission, is the burden that an originator such as AstraZeneca needs to satisfy when coming to court to ask for an injunction of this nature. So it goes to the question, as we've characterised it in our skeleton, of effectively uncertainty. And I want to start, if I may, by looking at the main cases, certainly the leading cases I understand it, so American Cyanamid, Factortame, and National Commercial Bank. The reason for that, of course, is they are decisions from 3 extremely eminent law lords, Goff and Hoffman, and they're spread over a period of from 1975 to 2009. And what I'm going to seek to show, my lords, is that these decisions show a consistency of approach. And the first thing that is consistent, which starts in my submission of American Cyanamid, is that, sorry, let me rephrase that, is that the steps in American Cyanamid are guidelines towards a particular purpose when looking at the application of Section 37 of the Senior Courts Act. They are not a rigid set of deterministic factors. They're obviously extremely important, but they are only guidelines. What is the purpose? And I'm taking the quote from Lord Hoffman and National Bank of Jamaica. The purpose is the court should take whatever course seems likely to cause the least irredeemable prejudice to one party or another. The next point is, self-evidently, in many cases, well, self-evidently in all cases, adequacy of damage, whether one can say that damage can be adequately compensated is an important feature, but it is only a feature of balance of convenience, and that actually comes from the very beginning, from the way that Lord Diplock discusses the matter in American Cyanamid. And why do I put emphasis on guidelines? I put emphasis on guidelines because what shouldn't happen in my submission is an absolute attempt at a fact-finding mission in relation to adequacy of damage if the evidence simply doesn't support it, and if the reason the evidence doesn't support it is not the fault of the originator, but is the fault of the disorderly entry into the market. After I've been through those, I'll go on briefly to have a look at some of the interim injunction cases that have been heard by the Patents Court or on appeal to this court from the Patents Court. And finally, I'm going to come back to the decision of the Supreme Court in Ireland in a case called Merck and Clonmel. And what I will seek to show, my lords, is that that actually demonstrates that what I've said is the right approach, and it's the approach that the Supreme Court in Ireland followed, having looked very carefully at the cases in this jurisdiction. My lords, if I may, can I go to tab 1 of the authorities bundle? This is American Cyanamid. I don't think it needs any introduction at all. And I can take this quickly. For my lords' note, though, my lords will undoubtedly will be far more familiar with it than I am. On page 408 of the decision, which is 14 of the bundle, that is the place at which, from B onwards, my Lord Diplock picks up the question of adequacy of damages. The only point I want to take to that is the word, if damages in measure recoverable at common law would be adequate remedy and the defendant would be in a financial position to pay them, then no interlocutory injunction should normally be granted. And I rely on the normally to say that this is not an absolute necessary step. In F, the first line, one sees, and this flows through these cases like a name through a stick of rock, where there is doubt as to the adequacy of the respective remedies. Now that is the doubt point, as my lords will have gathered by now, is where I put emphasis, but it's there from the beginning. If I can go over the page, could I ask the court to read from 408H to 409D. It's about half.
408H, the bottom of the page.
408H, and then over the page to 409D.
Yeah.
So my lords will have seen from that passage, this is the origin of this is discussed in the later cases such as Factortame. This is where the guidelines come from. One can see that adequacy of damage effectively in 409A is wrapped into balance of convenience. I draw attention to that. It's a point that Lord Hoffman came back to in National Bank of Jamaica, but again it shows there isn't necessarily a bright line between those two. And we see at the end in 409D, I referred to, special factors, not special features. That's the origin of special features. So, I'll get it right, special factors. Now, given the extremely well-known nature of this case, I've only gone to those passages because they're the ones that feed through into the later judgments. I was going to move on to Factortame unless my lord had any questions on Simon. Factortame, if my lords would turn to bundle page 85, it's in tab 2. And I am on that, I'm looking at the section, this is obviously a decision of Lord Gough, and I'm looking at particularly the section between F and H on internal page 167-185, and what one can see.
Sorry, page?
It's internal page 671, bundle page 85.
85.
So sorry, my lord.
Right. Yeah.
What one sees at 671, the primary point I want to pick up is the learned Lord Goff talks about American Cyanamid. One can see that in just below F, which is at the hole punch. And then he refers to what is said by Lord Diplock as guidelines. I use this as effectively where G is. I use the word guidelines advisedly because I do not read Lord Diplock's speech as intended to fetter the broad discretion conferred by the courts by Section 37 of the Supreme Court Act and Senior Courts Act. I could turn over the page very quickly, and I'll just give my lords the references to save time. And one can see that Lord Goff addresses the question of adequacy of damages from 672B onwards. And again, one sees doubt. And finally, again, at 672E, he quotes, and my submission with approval, unnecessarily with approval actually, Lord Diplock and the special factors. Unless my lords have any questions on fact claim, I could move on to National Bank of Jamaica. So National Bank of Jamaica is in tab 4. This is a 2009 decision. It's the latest of the three. Decision, as my lords know, of Lord Hoffman. And the passage I would like to go to is bundle page 119 and internal page 1409. And my lords, in paragraph 16, if my lords look where B is, one sees a sentence that starts, the purpose of such an injunction. And that was the passage I was, well, actually it wasn't quite the passage I was referring to earlier, but one sees there the question of doing justice and producing a just result. So again, the purpose, that is the underlying purpose. And then in para 17, which perhaps I can ask my lords, that my lords may very well be familiar with this, but if I ask my lords to read paragraph 17 quickly, I put particular weight on the basic principle sentence that says the basic principle is the court should take whichever course seems likely to cause the least irremediable harm, prejudice to one party or the other. Now, at this stage, I don't need to go any further with those basic authorities. They're basically there in my submission to put the clear outline of what the task under an American Cyanamid approach is. If I could, for completeness, go to Apotex in tab 3. There's one tab back from the tab we're in at the moment. And this is a pharma PI. My Lord Justice Jacob will be very familiar with this, but I'm sorry, my Lord Justice Arnold will be very familiar with this. This is a pharma PI case that came up from Mr. Justice Jacob, as he then was, and the reason for referring to it is to, if one goes to paragraph 38, which is on bundle page 112, internal page 558. This is the origin of the clearing of the way principle, or at least an origin.
It's not the origin of it, but it's the endorsement of it by this court.
My Lord, Lord Justice Arnold absolutely correctly corrects me on that. I'm so sorry. I think it was Lord Justice Jacob. I don't know whether Lord Justice Jacob below was the first or whether he'd been there before, but certainly my Lord. I'm grateful. And one can see what is being said there.
It's the case that you find reference to page 100. It's SKB and Generics UK back in 2001.
My Lord.
That's where it comes from.
But as I refer to it here under paragraph 39, which is over the page, and to the point that the reason that clearing the way, so this is page 113 of the bundle, page 559 of the decision, paragraph 39. That what is referred to there is that, effectively in my submission, is the principle that if one launches without clearing the way, then I will launch it precipitously, then the party launching precipitously is the party that causes the potential injustice. That's why the clearing the way principle, or a reason at least why the clearing the way principle is there. And I rely on it here, as I have said, because from the position of a party such as AstraZeneca, it is being asked to produce evidence on a very difficult basis immediately before the position will become clear, because the position will become, in my submission, clear at the FOO. So in my submission, when one takes these cases together, it's clear, and this is the quote almost verbatim from a decision of Mr. Justice Floyd, as he then was, the court has to do the best it can with the evidence before it at hearing of an interim injunction such as this. But in my submission, when it's faced with genuine uncertainty, and I'll come on to why I say it is in this case, it should not strain to make findings of facts as if it were at trial with the benefit of cross-examination. And we will, in my submission, see in this case that there was a clash of evidence, or appears to have been a clash of evidence, if there wasn't, my friend doesn't have a case at all, between Dr. McGill and Mr. Farrant. And that is not a clash, and I will show the relevant passages in due course, that in my submission can fairly be adjudicated on to come to a binary decision, and this is particularly in relation to reduction of prices, without cross-examination. And as I've said, I don't wish to repeat myself, Glenmark could have waited for judgment. If they'd waited for judgment, in my submission, the position would be exactly the same as it is now. The same two generics who wish to launch would have been ready to wait to launch in judgment. There's no advantage to launching early. They could also have piped up a lot earlier. Now, the position that they took in front of Dr. Tappin was that they had sought a trial in January 2025, and that is right. But they didn't say in January 24, which was the CMC, and if we don't get a trial in January 2025, then we will launch whenever we are ready, regardless of when the judgment is. Nor did they come back and update the court prior to the matters that kicked off this application at the end of February. So the next point I want to deal with on round one, I've addressed my lord on what I submitted the basic principles. I want to spend a few moments on how those principles have fed their way through into the IP cases, or the IP pharma cases. We have set this out in the judgment. I'm not seeking to do a sort of parity of reasoning argument where I say the facts were such and such in this case, therefore you ought to find in this case. I'm going there for, in my submission, what are some clear and basic principles. And I'm looking particularly, I seek to show three things. One, how the problem of uncertainty has been discussed. Two, why the Patents Court and this court, when it's upheld the Patents Court, have been at pains to emphasise the importance of the status quo as a way of dealing with uncertainty. Why price spiral cases are nearly always considered to be cause of unquantifiable harm. And then, as I said, I'll go to Clon Mal. If my lords have our skeleton to hand, this is the points I'm going to make now are set out in some detail in paragraphs 25 to 37. And I'm not going to go through them in detail. But I do say that when one looks at them and the quotes are there, there is a golden thread, and the golden thread is uncertainty. And all the cases we've quoted in paragraph 27, for example, Leo and Sandos, Actavis and Teva, which was a judgment of...
When you say uncertainty, you mean in relation to the adequacy of damage?
Yes.
Damages.
Yes, the uncertainty as to the ability to actually work out whether the damages are an adequate remedy or not, because one cannot see.
Yeah.
And what this shows in practice, and I submit is also shown in this case, you simply can't be certain how things will move in a growing market if the market becomes generic because multiple generics enter. And if I could perhaps go to the authorities bundle briefly. I'll take my lords to one other case that is in the bundles. It's at tab 16, and this is a case called Warner Lambert and Teva. Warner Lambert and Teva was a case concerning atorvastatin. It's taken to lower, as I'm sure my lords know, to lower cholesterol. And I'd like to go, if I may, to paragraphs 14 and 15. Now, I say I'm not trying to, this is obviously not binding either on Dr. Tappin or the court, but I do say what Mr. Justice Floyd says there accurately represents the sort of problem that the court is grappling with.
14 and 15.
14 and 15. So AAH for my Lord, Lord Justice Coulson, and Phoenix are both wholesalers. And so you see that what happened in this case, there's a short period of time pending a hearing that was a little way down the road, but not very far. They said it was very unlikely Warner Lambert would have to reduce their prices. If Warner Lambert stand firm on prices, then it's perfect recompense. Now, my lords will see why I have gone to that on the facts of this judgment. That is the standard argument of generics. It was, in fact, an argument run by Dr. Tappin as counsel in Cephalon as well. Now, so as I say, I'm not pretending this is binding on anyone, but if one looks at what Lord Justice Floyd says, that, in my submission, accurately submits a correct appreciation of what is likely to happen if a market becomes generic. It's going to become economically distorted. It's going to be irreparable. It's certainly not predictable. Now, it may be a case that my learned friend could have come here with some special economic evidence, which he didn't, and said, well, this is all very different in this case. I can tell you the market's not going to be distorted because he didn't in my submission, and the reason he didn't was his primary case was there was only going to be one generic, and that was him. The next point, which can also be taken from our skeleton, sorry, one moment, my lord. One sees a discussion of the case in which my Lord Justice Arnold was also sitting, which is the second interim decision. That's at tab 11. Sorry, the reference appears to have. I forgot the reference in the bundle, but it's in the bundle at tab 11. I don't need to go to it. We've set out at length a quote from Lord Justice Burse in paragraph 37 of that decision. And here, it's a different aspect of uncertainty, but still an important aspect of uncertainty. It's the part in bold. One sees that part of there is a real quantification problem. Sorry, my Lord Justice Coulson, have I given you the wrong reference?
How was the paragraph number?
Oh, I'm so sorry, paragraph 37. It's 37. Set out in our skeleton at paragraph 28.
Sorry, yes, because I went to 27 and that didn't appear to be Lord Justice Burse, it was my Lord, so yeah, fine. So
it's the paragraph set out at 28 of our skeleton, which is paragraph 37 of the Neuram 2 decision, and it's part of the judgment of Lord Justice Burse. And what, in my submission, Lord Justice Burse is explaining there in my submission absolutely correctly, that if you straining for a binary result may still lead to very great uncertainty, and that's the error bar point. Now the final point on this, if I may, before turning to Clot Marrow, the River Oxaban case, that is Bayer and Aspire, is in tab 12 of the bundle. I don't need to turn that up. That was a decision of His Honour Judge Hakon sitting as a judge of the Patents Court. But it's another example in my submission of the correct approach. In that case, they were 9 to 10 days away from a decision. There was an argument that there would be no unquantifiable loss to either party, and in very large part, His Honour Judge Hakon agreed with that, but nonetheless said, given the period of time and given the importance of uncertainty, the correct thing to do is to hold the ring until after judgment. And one sees that. We've set out the relevant paragraphs in our skeleton at paragraph 29 through to 32. I don't think I need to take my lords there unless my lords wish to be taken there. My lord, I said at the beginning I would turn briefly to Clonmel, and that was a decision of the Irish Supreme Court in 2019. It is in the bundle at tab 8. Clonmel, as my lords will have gathered, were the generic, in that case, Merck originator. And one sees, if I can, so I'll take this quickly because it's quite a long decision and I don't think I need to spend a lot of time on it, but if one goes to paragraph 16 and 17, that's on internal page 124. I do apologise that the copy here is not the best. One sees that the Irish court looked very carefully. It starts by looking at a quote from Carroll, but then over the page goes through many of the cases that one has seen in our scanner that we've discussed, looking to see how American cyanamid ought properly to be applied. And I do say it's a careful analysis of the UK cases between 17 and 22. For my purposes, the key section is on internal page 167, and there's a set of analysis. Actually, my lord, I'm so sorry. Can I go back to 166, paragraph 30? That's where the analysis starts. And if my lords would read over, it's a rather long passage, and I should have sidelined it. Actually, no, sorry. I'll do it a quicker way. What these paragraphs show, culminating in 33, is that adequacy of damage in particular, but the rules more particularly, should not be treated as strict mechanical rules. Obviously, adequacy of damage is very important and can be extremely important, as it refers to paragraph 34.
Key paragraph from your perspective is 35.
Exactly, my lord. I was going to go on to that, and perhaps I don't need to say any more than that. Exactly. I would also point to 36, is it reminds, not the court needs to remind me, but reminds practitioners that damage goes beyond pecuniary damage, and that is obviously a point, and I'll pick that up later. It goes to matters such as reputation as well. And then at the end, at para 64, there is a slightly modified or expanded set of guidelines, which is the ultimate result of the analysis of the Irish Supreme Court. And I would respectfully say these accurately summarise the position. They actually, in my submission, don't produce any new law at all. They're just an accurate summary of what's been said already.
Sorry, can I just look at 64? I've looked at the other paragraphs already for pre-reading, but I have to confess I didn't.
I'm sorry,
spot 64.
I should.
No, don't worry. Can I just read 64 to myself?
Yes, but if it's 6, 7, and 8, I put particular weight on.
Say again. 6, 7, and 8.
64, 6, 64, 7, 64, 8.
Yeah.
So sorry. I do have a paragraph 1b. I'll come on to, a ground 1b, which is if my lords disagree with me that this is an accurate statement of the law in the United Kingdom as it stands today, then it's a, I'll come back to it when I come back to it. So, just bringing this all together, in a case such as this, the court's being asked to assess the likelihood of future economic behaviour of multiple, highly sophisticated, highly well-funded parties. That is generally very difficult to do. It is generally not in the slightest bit deterministic, and it's very, very hard, by submission, to predict. And that makes it particularly difficult to conclude in the balance of probabilities what is going to happen. And that's all the more so in an application of this nature, where then evidence is necessarily limited, And those factors feed in. I obviously have to go into the precise facts of this case. I also need to discuss, submit to the court the situation when injunctions have been properly refused, where there hasn't been a risk. But I'd say when you take those points together, it drives you very rapidly to a conclusion that if one establishes that there is a serious prima facie risk of generic entry, particularly if one establishes that that is a large scale entry, then the principles in American Cyanamid of minimizing irredeemable harm very strongly favour the grant of an interim injunction, particularly in a short period when matters will become much clearer. My lords, the next point, which I can take quickly, and I don't intend to go through these cases because I've set out, or rather we have set out in our skeleton, the underlying reasons. There are obviously cases where interim injunctions have been refused. Sorry, just bear with me a minute. I'll just pull up the relevant passage so I can talk to it. It's set out in our skeleton between paragraphs 33 and 37. There are obviously cases where interim injunctions have been refused. The ones here, Cephalon, ICOS, and Neurim, are the ones that are referred to in Terrell. There may be others. But they're all very different cases from the cases we have here. Cephalon, there was a finding that it was most unlikely there would be a second generic entering the market. There also seems to be a question about the strength of the case in the first place. Actavis and ICOS is quite an exceptional case. I don't think I need to go through it, but one sees what Mr. Justice Henry Carr found. It is a world away from the case here. We've got fixed PAX prices, we've got settled market, and a rather extraordinary concession made, and I think it's recorded as a remarkable concession by Mr. Justice Carr about the ability to quantify damages, and that's in our paragraph 35E. And then Neurim again, only one generic competitor. What is, in my submission, most striking about the present case is, in comparison with those cases, its normality. This really is, in my submission, on the evidence, a very normal multiple generic entry type case. And there's nothing that my learned friend can point to in my submission that takes it out of that kind of norm. There's nothing here. We obviously know there's multiple generics, but there's nothing here. There's no concession of the sort in ICOS, and there's no finding on the strength of the case such as there was in Cephalon or ICOS. Those are my submissions on the law on ground one. I now need to go, if I may, I now need to go to the judgment briefly and the facts, and to make good my submission that the learned judge rather lost sight of some of these factors when he carried out his analysis.
No.
And my underlying point, as I'm repeating myself now, is that the learned judge overly strained to resolve the question of adequacy of damages on the basis of the evidence before him. If he had kept his eye properly on the issue of certainty, and on the basis of his own findings of fact, he should have found that there was a likelihood of damage to AstraZeneca that couldn't be compensated in damage. The submissions I'm going to make bite on two things. They bite on his findings in relation to the dropping of actual prices, which he did by inference from the list prices, and in the teeth of a clash of evidence from Dr. Gill. And they bite on his findings in relation to putting actual prices back up again. Ultimately, some of these points are also engaged additively with ground 2, but I will leave ground 2 aside and deal with that separately. But obviously, at some level, the points arise as well. If I might turn to the learned judge's order, the learned judge's judgment, which is tab 6 of the core bundle. And the first paragraph I would like to go to, if I may, is on in bundle page 54, and that is at judgment paragraph 62. And I could ask my lords, I mean, I know my lords would have read this, but the point I wish to emphasise is the first point, which I submit is right. It is impossible to estimate the likelihood of there being a drop in generic prices in the form of order hearing. And so he goes on, and then he says, I can't say there isn't a real risk. Now, it's clearly right in my submission that one cannot estimate at the stage the learned judge was dealing with this, exactly how many generics are going to come on, exactly how fast they're going to come on. That is a matter of extreme uncertainty. It was my client's case, now I submit made good on the post-hearing facts that the generics would pile in as soon as possible. That is what happened. But the only conclusion I can submit one can reach on the basis of the judge's finding is that there is a very real risk of multiple generics coming onto the market before the formal order hearing. There's certainly no basis for excluding that possibility. Now, the judge didn't really exclude that possibility, but I just want to start here because I do say this is a necessary piece of background as to the nature of the market. Now, the way the learned judge continues in 63 engages the clash of evidence in my submission. So the learned judge refers to the evidence of Dr. McGill. And I need to unpack that a little bit, if I may. If I could go to the supplementary bundle, tab 2. And in tab 2, I'd like to go to paragraphs 48 to 56. I should say first that there's Dr. McGill's background, her ability to give evidence set out at the front of this witness statement, and there was no criticism of her by the learned judge whatsoever. And that obviously, when we looked at the background, there's no reason why she couldn't give the sort of evidence that she is giving. And if I can start by asking, I mean, if the court has read this already, I don't want to ask you to read it again, but as do say, paragraph 48 sets out Dr. McGill's overall position. He says a price spiral, if multiple generics enter, is likely to occur. It says once the NHS has become accustomed to lower prices, it's unlikely to restore. Then she gives reasons for that. She says they'll be especially resistant because of the sheer size of the market. Now, that is, I think the actual size of the market is a confidential piece of information. It is given in our skeleton. It is many hundreds of millions, or it is several hundred millions a year. Points out that the cost of the drug to the NHS is very large, and she points out, and she makes these points in my submission good later, that it's an unstable market, to use my shorthand for the growing market point. Now, I don't wish to take my lord through the evidence in detail, but she goes through what she expects to happen, and then the passage the judge in my respectful submission is referring to is paragraph 54. Now, remembering that this is being given without knowledge of what is actually going to happen. This is being given, therefore, without knowledge of how many generics, how fast, how much. And in a position where, in my respectful submission, AstraZeneca could not possibly say in advance precisely what they were going to do to militate the position. So what Dr. McGill then says is AstraZeneca will be put in a difficult position. Choose to reduce its price, but if it does that, it loses market share. Sorry, James, this is what she said. Oh, I'm sorry, I've been told I've misquoted that. My lords can see, it will progressively lose market shares that generics enter the market, and once they saturate the market, will lose virtually all its sales for in. And that's why I explained in at the beginning. That's the stuff that can provide, that's the 90% of this type of drug that can be prescribed generically. So that's unpalatable option number 1. Unpalatable option number 2, if it does choose to reduce the price of Forxiga being the main drug, it will reduce its profits from branded prescriptions, and it may see a reduced price impacting its other markets. And then she goes on in 55 to say, over time, having grown accustomed to lower prices, and is pointing out that lower prices, we want to, having a customer to lower prices, be highly resistant to the budgetary impact of a return to the original price, and so it goes on. And then she gives some other reasons as well, which I'll turn onto in time. Now, going back to the judgment, para 63. Tab 6 of the core bundle 63. The judge appears to criticise, or at least give insufficient weight to what Dr. McGill is saying. Well, I do submit that what Dr. McGill is saying is entirely the evidence you would expect to give from a company in AstraZeneca's position. What other evidence can she give that they are placed in a position, both of which I say are unquantifiable, that they will have to reduce their selling price, or sorry, their price, I shouldn't say selling price, I'll be picked up on that, but she says price, which I submit means selling price, but I'll come back to that. Or they will have to lose market share. Then, if I can move on to the judgment on to 73, one sees, and I'll come on to Mr. Farage in a minute, the judge finds that AstraZeneca would not reduce its list price in reduction, and it says it can reverse its list price without obstacle. Now, as my lords will remember, the list price is set by the NHS. Now, the judge also makes a finding, and I will come on to that, about the actual price in a minute. But there is an underlying point here. The evidence from Dr. McGill, and I've shown you paragraph 55 of Dr. McGill, is that there would be considerable difficulty in raising the prices to the NHS once they had become accustomed to lower prices. Now, he has rejected that in my submission effectively. I'll show you how he's rejected it and why I submit that A, that's wrong in principle, but B, it is straining to a solution that is simply not possible on the facts before him. And what he's ignored in my submission is the fact that Dr. McGill says it's just going to be very difficult to renegotiate. And one can read into that quite properly in my submission, as there was read into the cases in Apotex. What that means is a loss of effectively negotiating goodwill. You have to burn your credibility in goodwill if you're going to insist on a higher price to an NHS that's become accustomed to a lower price. Now, I'll come back to that in a minute, but if I may, I want to turn briefly to Mr. Farrant's evidence, because this is the origin of the list price argument and the ability to come back up on the list price quickly. And just for your note, we're in our skeleton and we are at paragraph 42. I've already explained how that is different from the actual price. I've already shown you paragraph 51 in Mr. Farrant, where Mr. Farrant acknowledges that originators can reduce their selling price to the NHS, sorry, to wholesalers. What is then very striking is that Mr. Farrant only really deals with list price. He mentions in 51 that the originator, in fact, perhaps I should turn this up. If Mr. Farrant's evidence is in the supplementary bundle at tab 8, I'm going to start with paragraph 51. Now, he is, I accept here, talking about a fall in the in-reimbursement price, but nonetheless, he talks about the originator not reducing its selling price. And that's the only place where he refers to, as far as I'm aware, selling price. Because when he goes on in 94 and 95, which are paragraphs my learned friend made a great deal on, both in front of the learned judge below and in his skeleton, he is talking about list price. So if I could take my lords to page 122 para 94. I do not expect, as 94, AstraZeneca would decrease its list price over the course of the first period. Then he gives a number of reasons. And then he goes on in 95, he talks about, he says, provided AZ maintain its list price, so its previous levels of profits will be restored as soon as exclusivity on the market, etc., has come back. That process will be automatic, and that can only mean automatic can only be a reference to the list price. And then he goes on, there's no mechanism for the DHSC or NHS to intervene. This is all about list price. It is not about selling price. And the striking thing about this evidence is, with the exception of para 51 in my submission, it doesn't deal with anything but list price. And I should say, just in case I'm pulled up on this, there is one place otherwise in the skeleton, which is para 92, where Mr. Farrant is talking about various quantifications, and just before his little equation, he talks about the current list price. Underneath, he talks about its price. Now, I say that the primary reference there is to list price, but if I'm wrong on that, that is the only other reference to price than the ones I've shown you that isn't list price. Now, if I may, can I take you, my lords, to the judgment of para 66 and 67. Now, what the learning, sorry, I should say before, in 64 of the judgment, the learned judge accepts the evidence that AstraZeneca wouldn't reduce its list price. Goes on in 66 to talk about rebates. The learned judge then says in 67, no, neither Dr. McGill nor Mr. O'Toole, who was another AstraZeneca witness, said AZ would be likely to change its actual price to wholesalers. Now, in my submission, I've shown my lords the evidence. I don't want to go back over it. I think I respectfully submit that is a mischaracterization or a rejection, in effect, of what Dr. McGill was saying. Immediately above that, and I do need to deal with this, the learned judge also accepted, and I do submit, I have to put this, that he was wrong to do so, that my learned friend Mr. Abrams' submission, that the reasons given by Mr. Farrant for why AZ would not change its list price also applied to the actual price. Now, that is simply not right. So, my lord, if I can take you to the best place to see the reasons, I think, is... Sorry, just one moment if I may. Yes, sorry. My note went badly wrong there. They are actually, the reasons I want to go to are enumerated in the judgment immediately before what we've just been. My apologies for that, my lords, and I'm grateful to my junior for pointing that out. If my lords were to go to para 64, you see there are 6 reasons given why the NHS would not lower its list price. First is market share completely restored, but that really begs the question about unquantifiable loss, and I'll have to come back to that point more generally. Second point, single market entrant. Well, that's obviously no longer relevant. Third, to the extent the whole of the in-prescription market was not satisfied by generic supply, that's an assumption that the market would not be saturated by generics. I say that is now, it always was in my submission, but it certainly is now, an assumption that can't be made in the light of facts that have come to light since the hearing. The fourth point, AZ will retain its profit margin on the branded share of the market. That's the non-INN share. That is correct, but it is but 10% of the market. So that does apply as a point that can come over to actual price, I suppose, but it's not a very important one. Fifth, drop its list price, obviously doesn't apply. Sixth, can't raise its list price. Well, fifth and sixth obviously only apply to list price. So I do say there's a bit of a problem here that the reasons that the learned judge accepted as being reasons why the actual price would not be dropped for list price may be right, but that doesn't follow their right for selling price. And that's in the light of evidence from Mr. Farron that is, for the reasons I've said, very tightly focused on list price. And that is in the face of evidence, which I say is very clear in paragraph 48 onwards of Dr. McGill about the position AstraZeneca would be in. And repeating it myself again, but the learned judge has not found that Dr. McGill was an incredible witness, was wrong, and in a sense hasn't criticised her specific evidence. And finally, all this ignores market share. Let's remember that in paragraph 48, Dr. McGill said there were two unpalatable options. So she doesn't use the word unpalatable, but they are clearly unpalatable options for AstraZeneca. One is to lower its price to try and hang on to its market share. The other one is to stick firm on its price, but slowly lose market share. Well, that second option is also very difficult to quantify. I should, for completeness on the list price point, go to one other piece of evidence. That's a piece of evidence given by Mr. Meanwell, which we haven't been to. We haven't been to Mr. Meanwell. Mr. Meanwell is a Glenmark executive, and that is found at tab 7. Sorry, tab 7 of the supplementary bundle, my lords. And it's paragraph 26. And as it's highlighted by my learned friend's clients as confidential, I'll ask my lords to read it. Point for going to it, obtain a full list price. And in any event, if I'm wrong on that, and this does clash with Dr. McGill, how can Mr. Meanwell be in a better position to give that evidence than Dr. McGill, who is obviously an AZ rather than a Glenmark executive? How can the court possibly resolve that without cross-examination or considerably more evidence than we have dealt with? As prices going down, what about prices going up? I've taken you to the evidence of Dr. McGill, where she said it would be very difficult if the market becomes generic to get prices back up. My lords will see where I'm going with this is that the evidence on list price is a different point. Obviously, the list price doesn't shift unless the NHS shifts it. So all this point about being automatic is a function of the list price. It's nothing else. And in my very respectful submission to the learned judge has fallen victim to a very elegant sleight of hand by my learned friend by mixing up list price and actual price. And a number of wrap-up points on paragraph 66 and 67, which are uncertainties which I submit the learned judge should have taken into account. When making those findings about AstraZeneca's economic behaviour, and that's what they are, he did not know, and AstraZeneca did not know, what the size of Glenmark's initial entry would be into the market, which in my submission is a very good reason why Dr. McGill can say relatively little. Anyone sees that she balances, by her position it's balanced. It doesn't say anything, we knew nothing about the price of Glenmark's entry. Now the judge assumes, and I can't go behind that, it's probably 10% to 20% lower if it's a single entrant, but we're no longer a single entrant market. it cannot take into account the timing, the size, the price of any other generic entry. So in those circumstances, I do submit it is extraordinarily difficult for a party in the position of AstraZeneca to put in any more detailed evidence than the evidence it actually has. It simply cannot say what it is going to do on one of a myriad of different counterfactuals. What is more, this is the point on Mr. Farrand, is that no doubt Mr. Farrand gave his evidence honestly to the best of his abilities, but a lot of his evidence, not all of it, but a lot of it goes to saying, I agree, I think there's only going to be one market entrant. Well, he's been proved wrong on that, and that goes to show how fallible guesses are, in my submission, in a situation such as this. One has to take the greatest care. It's not a question of saying the witness is careless or dishonest or anything else. It's a question of saying what the witness is trying to do is to look in a crystal ball about very complex economic behaviour. And the final point, I don't want to labour it, but I'll come back to it. Of course, the reason we didn't know, at least until after the hearing, what the other generics were going to do is until they got wind of Glenmark's launch, they kept their powder dry. And therefore, the uncertainties that the judge faced and AstraZeneca faced were uncertainties caused by the failure of Glenmark to clear the way. Those are my submissions on the primary ground one. I'm conscious of time. Unless my lords have any questions on those, I was quickly going to go over ground 1B, but I'll spend very little time on that.
No. So we're going to ground 1B.
Very quickly, I think, for completeness.
Yeah.
My lord will see, effectively, it is run in the alternative to 1A. My uncertainty point doesn't require any real modification or extra elucidation of the test in American Cyanamid. It doesn't require, in my submission, my lords, to actually play down the question of adequacy of damages provided uncertainty is taken into consideration. But what 1B says is, in any event, my lords are not subject to a straitjacket where there is has to be a deterministic finding of adequacy of damage. That's the purpose of taking my lords through those decisions in American Cyanamid, Factortame, and so on. My lords are applying Section 37 to do justice. And in these circumstances, I do say there are special factors, to use the wording of Lord Diplock, that suggests in a case such as this close to a form of order hearing, there are as an entirely different route, effectively, to get to the interim injunction. And those are, and my lords will be unsurprised by what I'm about to say, is that the uncertainty and difficulty is caused by Glenmark's choice to launch precipitously when they hadn't made a proper attempt to clear the way. I do say merely asking for a trial back in January 24 for a trial in 25 cannot be satisfactory when the consequences of that are what is now a disorderly launch immediately before a carefully reasoned judgment on validity, which will doubtless change the status quo again. And finally, the time between now and judgment really is extremely short. And that's the point, just to address a point, that's the point my Lord Justice Arnold raised. A similar point was run to as a Supreme Court appeal point in Interim, and the question of the Clonmel type approach found some favour with the Supreme Court. In my submission, I don't need to go that far before my lords. Today, I say
it's an overstatement to say it found favour. They accepted that there was a question of law of general public importance.
My lord, yes, I'm so sorry. My lords. No, they didn't. They didn't.
Or the other one.
No, my lord. No, my lord is absolutely correct. I'm sorry, I didn't mean to overstate it. My point is, in my submission, my lords, this isn't, in the way I put my case, a point that requires the intervention of the Supreme Court. All the tools and levers necessary for a decision on ground 1B are set out extensively in the earlier cases, so in National Bank of Jamaica, Factortame, and American Cyanamid itself. And so it is open to this court, and I would respectfully submit this. It does engage the policy points to say that in circumstances like this, where the way has not been cleared, where time is short, regardless of any other consideration, it is appropriate to grant an interim injunction to maintain the status quo. My Lords, that's ground 1B, unless my Lords wish me to make any further submissions in relation to it.
No.
Oh, actually, sorry. I realise I have forgotten, that was in my note, but I had forgotten to actually wrap ground 1 up with the balance of convenience, which I should do for completeness, lest it be said I haven't said it. My submission, in conclusion on ground 1, learned judge has erred in his approach because he has tried to make certain that which is fundamentally uncertain. So he should have concluded that damages were not an adequate remedy to AstraZeneca. And certainly if he's erred in his approach, my Lords are entitled to take into account the realities now, which undoubtedly they are. And as far as the balance of convenience is concerned, on the redeemable risk, my submission is actually very simple. It's not about quantification of damage. It's about after the event and who's going to get slightly more back. The real point is, if the market becomes generic, the potential loss, if it's unquantifiable, to AstraZeneca far exceeds that to any one generic such as Glenmark. And therefore, I say that the finding on 102 of balance of convenience is simply not right. If I may move on to ground 2, and my Lord, I can pick this up in our skeleton at page 15. And as I have already said, and this is in the judgment of para 31, just for my Lord's notes, the judge rightly directed himself that he was looking at unquantifiable loss caused, as far as AstraZeneca were concerned, caused by not granting an interim injunction. But he rightly says, absolutely rightly says, that loss may manifest itself before or after the form of order hearing. And what I want to seek to make good under this ground is that he has failed in his appreciation of the latter part, that is the post or at or post form of order hearing. He hasn't dealt with that in my submission correctly. And I have to deal with 2 points. There is a procedural objection, which I submit is a bad procedural objection to running this point at all. My learned friend says I didn't run it below. I submit that is wrong on the evidence and on the transcript. And then I need to deal with the substantive point itself. So the other point I need to deal with is if my learned friend is right and this wasn't run below, then I do say this is one of those sing and das type points that is appropriate to be run on appeal, and the reason for that is it comes straight out as a matter of the judge's logic on his finding, and there is a lacuna in that logic which is plain on the face of the judgment. So my first submission, if I may, in dealing with was the point run. Now there's starting at the very beginning, my Lords will have seen that the purpose of this application for an interim injunction was to hold the ring pending the form of order inquiry and to make sure that the court was able to exercise its discretion in relation to matters such as injunctions, pending appeal, going forward, on the basis of a non-genericized market. That is the whole purpose of this application in the first place in my submission. And that is why we are not seeking an injunction at this stage until the conclusion of this action in its entirety, in the conclusion in the Court of Appeal, if that is what happens, because AstraZeneca accept that the status quo may, indeed likely will, change at the point at which Dr. Tappin hands down his judgment in the validity.
Well, the market status quo won't automatically change, but the relevant factors.
Sorry, yes, not quite so. The relevant factors for the court will change. And that is why this application was brought to hold matters over until the form of order hearing. Now, it's easy in my submission to be beguiled by the fact that the main argument, as I've always already alluded to in front of Dr. Tappin, was, is it going to be a single entry or a multiple entry? But it is clear, and I'll come on to this in detail, that the kinds of damage, kinds of loss that were being referred to by AstraZeneca were losses that could occur either before or after the form of order hearing. Now, it is correct, and I don't resolve from this, AstraZeneca's primary case is that they would occur before the form of order hearing, and I've addressed my lords in ground one of why we say the learned judge was wrong on that. But even if I am wrong on that, I submit that things such as the difficulty raising prices, the question, I'll come on to this specifically, of NHS reclassification, so from C to A and possibly M, removal of support by AstraZeneca for various forms of SLGT2 funding, changes in supply route, are all reasons, and they're reasons in evidence, that depend on time. They may happen before the form of order, they may happen after the form of order, but they are still there and they are still in evidence. And I'll come on to that. The first place I need to go, if I may, my lords, is to the transcript of the hearing in front of the learned judge, and that is in the supplementary bundle at tab 20. And I'd like, if I may, to go to page, transcript, page 6.
Bundle page.
Bundle page 197, my lord. And if my lords were to read from transcript page 6, line 16, which is where the judge is putting matters to me, down to page 7, line 10. In fact, my learned friend asked you to read to 18. I'm very happy for you to do so. So at the very start of the hearing, AstraZeneca agreed with the judge's point that damage is including damage after the form of order hearing. And then there's the reference, which is the reference below 11 down to 18 of the rivaroxaban case. Now, that doesn't take matters any further. I've already explained why AstraZeneca were not asking for, and they're perfectly entitled not to ask for, an injunction pending trial. They're perfectly entitled to say that needs to be dealt with at the form of order hearing when the other generics enter the market. Doubtless the court will have other factors it wants to take into account. And the reality is, of course, there is a real possibility, depending on what the judge found, that Glenmark would come back and ask to lift the injunction in any event. So the orderly way to proceed in my submission is to ask for the short form injunction to the form of order hearing, and then see how the chips fall thereafter. Now, I keep referring to the uncertainties in the form of order hearing, and my lords will have them, I'm sure, well in mind from our skeleton paragraph 15, but they do in my submission bear repeating. By that stage, the market will either be, in my submission, one has to conclude now, fully or partially generic. Dr. Tappin may have found the patent valid or invalid. Whichever basis he does, we won't know until that judgment is handed down. There may or may not be permission to appeal from either any of the parties, depending on what happens. There may or may not, and this is an important point, based on the facts on the day of the FOO, be an interim injunction pending appeal. And of course, the other generics will have surfaced and they will doubtless have something to say about the matter. And the whole point of this application is to keep the market clean until then, so one is not entering this kind of market with a generic starting point, because that's a very different starting point from the starting point we're dealing with now. Now, my learned friend will keep pointing to that's not me saying, or the skeleton saying, that is not a matter for today. That needs to be broken down a little bit. What I mean by that is the decision, I submit, is absolutely clear, that the decision at the FOO as to matters such as an interim, form of order hearing, I shouldn't call it a FOO, is a matter that will have to come before Dr. Tappin in due course. I can't prejudge what AstraZeneca's submissions will be at that stage. So if I were to go to our skeleton below, that is a supplementary bundle tab 22. We go to paragraph 12, and that is on page 6. And I would point to paragraph E. I've said several times that we were asking to maintain the status quo. That point is there. Now I'll come on to the question of damage if the status quo is not maintained in a second. I'll go to that one to make good the point, which I say was very clear from AstraZeneca's submissions, that we were concerned with holding the rein. If I could get back to the transcript, if I may, at paragraph. Sorry, I'm in the wrong bundle, my lords. My apologies. In the supplementary bundle, tab 20. And to go to, this is bundle page 200, transcript page 17. Then I would ask my lords to read down from 1724 to 1814, where it says the seal has been broken. Slightly clumsy wording from me, but I submit that's very clear. The seal has been
I'm sure you put it more elegantly in the past than a little bit of a golden thread with status quo.
My lord, I don't think I can legitimately comment on that.
It sounds like two rock songs from the early 70s melded together.
My lord, yes, which gives away my age. My lord, perhaps I can go on to
Sorry, down to paragraph, line 24.
1814, sorry.
Oh, 14. Yeah.
So sorry.
Yeah.
The next place I need to go to, if I may, is in the supplementary bundle tab 1, and that's the witness statement of Mr. Stothers. Mr. Stothers is AstraZeneca's solicitor, and I might just go to paragraph 43, which is on bundle page 13. And it's the second sentence I would ask my lords to read. Would starts any. Sorry, my lord. Starts any harm that Glenmark may suffer by being enjoined for that limited duration is a minor relative to the irreparable harm that AstraZeneca will suffer if Glenmark is not enjoined, with losses that extend for many years into the future. No suggestion anywhere in my submission that AstraZeneca said, no judge, please do not look at any damage that accrues after the form of order hearing. On the contrary, as I've shown, my lord, AstraZeneca agreed that that was the correct approach. And as we've just seen, indeed, that was Mr. Stothers' evidence. And I said a moment ago, I won't go back to it, but one sees from Dr. McGill's evidence about things like NHS reclassification, the growing market, damage to the supply chain. These are all ongoing matters. Now, they were advanced primarily in relation to, I'm not going to say otherwise, they were advanced primarily on the basis that they would occur if there was enough time before the form of order hearing. But they are nonetheless good evidence in relation to what happens, full stop. And they certainly weren't I'll show in a minute, they were rejected by the judge as a relevant consideration on timing, not on substance. The next place I need to go, if I may, is back to the judgment. My learned friend relies on what the judge says between 28 and paragraph 28 and 30 of the judgment. And in my submission, that just doesn't make his point good. All this does is to repeat that AstraZeneca were only seeking an injunction up to the form of order hearing. There's nothing here to suggest they were arguing that damage caused before the form of order hearing was somehow not admissible. And also, as one sees again here, the point at the top of the paragraph 28, which in my submission is absolutely right, one cannot be confident of what relief is going to be granted pending the outcome. The further point raised by my learned friend goes to paragraph 87. Sorry. There's a bad reference in my note. I'm so sorry, could I just take a second? I've got a bad reference in my note, I just want to try one. Okay. I'm sorry, I'm so sorry, my lords, that's entirely my fault. My notes went awry. I am looking at my learned friend's skeleton, and I am looking at his paragraph 32. He refers at the bottom of his paragraph 32, sorry, my lord, at the bottom of his paragraph 32 to Stothers 1 para 43. That's the paragraph I have just shown, my lords, that talks about losses that extend many years into the future. So that seems to be wrong. And in addition, I'd like to pick up on the point he talks about our skeleton argument below at paragraph 87, and perhaps I should go to that briefly, because that's on a very different point. That's on a point about Glenmark's position, and Glenmark were in a slightly strange position here. So that is a supplementary bundle tab 22, paragraph 87. Now, we're talking here, this is AstraZeneca's, sorry, so that's bundle page 284, tab 22. All right. We're talking about cross undertaking. And the point, it's not an even balance between AZ's position and Glenmark's position. The point that is being made here, the primary point, is the bit after furthermore, and that is, as my lords may have seen, Glenmark's position in their evidence was if the patent is found valid, then they would not object to an interim injunction pending appeal. Sorry, my lord.
An injunction anyway. Sorry, I think I was misspeaking.
My lord, the point was that the Glenmark advanced evidence about what they said they would do should Dr. Tappin find the patent valid and should no other generic come on the market, which is they would submit to effectively an injunction. They wouldn't ask for a stay of a permanent injunction pending appeal, and therefore they were content, has to be assumed they were content with the cross undertaking they would then get in those circumstances from the date of the form of order hearing until my lordship's court has disposed of the matter. So I'm not sure I really understand what my learned friend's point there is. I'll come back to it in reply if I need to, but it doesn't seem to make his point good. His next point in his skeleton relates to paragraph, which is in his paragraph 33. He goes to the, sorry, it's in paragraph 32. He goes to our oral submissions, and perhaps I should pick those up and show those to my lords. They're in tab 20.
So paragraph 32 of Mr.
I'm so sorry. Can I start again?
Abraham's skeleton. Which particular bit? We looked at
the
the reference to the oral after the reference.
So sorry.
Yeah, that's right.
Well, we looked at pages 6 to 7.
Yes, we should perhaps look at page 10, my lord, which is his point, lines 4 to 10.
Page 10 of the transcript.
I'm sorry, my learned friend said something. Yes, page 10 of the transcript, which is 198.
Yep.
And this is the same point. This is, I'm just merely reiterating, if they submit to judgment, sorry, no, I'm so sorry, if they submit to an injunction with a cross undertaking, how can it lie in their mouths to make this point now? Now, my lords, I've been at some, just stepping back, in any event, the underlying point, my submission is twofold. One is the learned judge's finding, which I have already been to, that he had to consider later loss. Two is, in my submission, the clear position of AstraZeneca that the whole point was to maintain a pristine market, to allow the decision at the form of order hearing to be made in an orderly fashion without generic pile-on. If I am wrong on that, and my lords conclude that the point was not run below, then I do have to make an application under CPR 5221(3), which is the Notting Hill and Sheikh Singh and Das type jurisdiction that is referred to in our skeleton. I will take that, subject to my lords, fairly quickly. In my submission, the relevant principles are set out in Notting Hill, which is at tab 19 in the bundle. 19, my lord. Para 25, which quotes from Singh and Das. Perhaps, my lords, actually, I should not take it quite this quickly. We should get to tab 19, para 25. Judgment of Mr. Justice Snowden. And Mr. Justice Snowden at para 25 looks at the decision in Singh and Das, which are the decision of this court, and in particular a speech of judgment of Justice Hadley Cave. Caution, yes, but one sees that the key points here are: does it necessitate new evidence? Would the trial have been run differently? Is it a pure point of law, and so on? And in my submission, if I am wrong, this is exactly the sort of point that this jurisdiction allows and should allow to be heard on appeal. Sorry, noting also the test is no longer exceptional. That one gets that from both Notting Hill Finance and Singh and Das. There is no need for new evidence. I am not relying on any matter that is not a pure submission or evidence that's already in the case. It is a point that directly arises from the learned judge's finding, which I have taken you to below. And the point that I wish to make, wish to advance, is that there is a lacuna in that finding, and that is a lacuna that I submit he ought to have filled, and leads to an error that is clear on the face of the judgment. It's a logical mistake, and it's certainly not a case that AstraZeneca have said shouldn't. That isn't right, so I'm not arguing against myself. And also, this is in the context, of course, this is not a fully forged trial, but a comparatively rapidly brought on interim injunction in a complicated matter. Are there any matters in relation to the Singh and Das type jurisdiction that my lords would like further submission on?
No, thank you.
I will take, I'm conscious of the time, just to give my lords a heads up, I'm now on to the final two laps, which are the end of ground 2 and ground 3. I would imagine it will take me perhaps 10 minutes more than 1 o'clock, so 10 minutes after the short adjournment, if that is convenient for my lords. I know that eats 10 minutes.
You need that long?
I'll do my very best not to, my lord.
Well, why don't we try and do it so that the short adjournment is the natural break? I mean, I'm anticipating Mr. Abrams will be less time because you've opened some of the stuff, but
Yes.
we need to try for equality of
I will,
timing.
of course, my lord, and I'm very conscious of that. My lord will have seen, so this is turning on to the problem. What one sees, if my lords would turn to the judgment again, which is at tab 6 in the core bundle, I want to point to the 2 paragraphs. 68 we've already seen. This is where the judge says there's no evidence would like to change its actual price. I've dealt with that. And if it did change its actual price, it would not be able to reverse that without obstacle. And if one turns over the page to 73, sorry, if one turns to paragraph 73, which is at the bottom of this page, and goes over the page, one sees again a reference to reverse any steps thereafter without obstacle. Now, the only way they can be reversed on the basis of list price is if there is an interim injunction removing the generics from the market, effectively, or certainly on selling price. And it seems to have been, in my respectful submission, that the learned judge rather lost sight of that aspect, that having found that judgment para 28, that he can't, and quite rightly can't say what's going to happen, can't assume what's going to happen at the form of order hearing, he's then effectively said, I'm going to look at this period of damage up to the form of order hearing, and I'm only going to take one of the possible situations, and that is that AstraZeneca can return the market to its product only because the generics are removed from the market. Now, that I've already been through, and I don't think I need to go through again, the multiplicity of possibilities there are at the form of order hearing. But one is, of course, that there is no further injunction. It's highly likely that the only way, I'm sorry, let me step back, the only way in which the judge's analysis could be a perfect, complete analysis would be if there's sudden death of this action at the form of order hearing. And that is in circumstances where, whatever the outcome, Dr. Tappin and this court both refuse leave to appeal. Now, that is, in my submission, a highly unlikely possibility in this action. There are 3 reasons for that. One, the nature of this action means that they are generally appealed, but more importantly, and I don't think if anyone's complaining, give the evidence, I will withdraw it, but one of the primary, if not the primary, attacks on validity in the court below is an attack on what is called plausibility in patent law, and there are difficult issues of law in relation to plausibility. One might assume that there's going to be a reasonable chance of those being appealed to my Lord's court. If there's permission to appeal, then there's a real question about is there or is there not going to be an interim injunction pending the end of that appeal. That depends on a multiplicity of factors. There's obviously a very different timing from the timing today, but if there is not one, then AstraZeneca do not get to be put back in the position they were at the form of order hearing. They get to suffer the generic market all the way to the end of the appeal. And then if at the end of the appeal their patent is upheld, my submission, they can't be put back in the same position. The seal, as I put it to the judge in paragraph 7, has very much been broken at that stage. The market has been generic for a long time. Multiple generics we now know will have launched. They will have established market share, they will have established goodwill, they will have established early mover advantage. All of those are the effect of those are all unquantifiable in AstraZeneca. The NHS, the evidence was they reclassified every quarter. Well, 1 to 3 months is about a quarter before the form of order hearing. Self-evidently, shortly after the form of order hearing, I can't give evidence on when because I don't know, there is likely to be reclassification. That was a point rejected by the judge, and that's at J69. But he doesn't say, nor could he say in my submission on the evidence, that recategorization won't take place if the market becomes fully generic. He merely says they're unlikely to recategorise before the form of order hearing. Well, if they're not removed from the market, then recategorisation will take place. Losses that associate with that then become flow. The judge also found, this is in paragraph 75 of the judgment, there was no risk of changing the supply chain in the period 1 to 3 months before the form of order hearing. Again, if the market remains generic after the form of order hearing, his finding, he doesn't find that AstraZeneca wouldn't, there's no risk of them not changing the market. He merely says there's no risk in 1 to 3 months. Well, if there's not an injunction, the same argument runs. Same argument runs in relation to paragraph 78 of the judgment. This is the question of whether AstraZeneca will be forced to reduce or remove its support for various SLGT2 working groups. Those are ones that were promoting, they're the joint workings that are promoting the use of this type of drug for new bases and larger uptake. Again, it's rejected by the judge on the basis that it wouldn't happen in the time before the form of order hearing. And in those circumstances, I submit the evidence I've taken you to, paragraph 55 of Dr. McGill, about the difficulty of putting up prices again, sings even louder than it does now, because then the market will have been generic for a very long time indeed. But there's a more important point than all of this, and I think this is a necessarily inherent point in any of these arguments, is that when Miss Lane King's counsel, who represented AstraZeneca at the validity hearing, stands up at the form of order hearing, if she is instructed to make an application for further interim relief, if there is an interim injunction now, she will be making that application in circumstances where the market is not generic. The status quo is exactly what it is today. If she makes that application without the benefit of an interim injunction between now and the form of order hearing, the market will be fully generic in my submission. We know that Teva will be on the market, we know that generic X will be on the market, we know that Glenmark will be on the market. And they will doubtless say at that stage, particularly Teva and generic X, because none of this is their fault, we will suffer unquantifiable loss if you take us off the market now, because we've just spent the last 3 months building up our supply chains. We have spent the last month building relationships with investors. We have captured market share to a certain extent. All this is unquantifiable, and therefore AstraZeneca's position making that application may be altogether more difficult. Now, I'm not saying it's impossible, self-evidently. It undoubtedly will, highly likely it would be AstraZeneca's position, they would apply. I don't know. But if they do from the face of a generic market, that is a very different form of application from an application that is made in a market that is not generic. So taking all those points together, I do say that the learned judge lost sight of the different options for loss to AstraZeneca after the form of order hearing. I've been through those now, I've pointed my lords to the evidence in those, and I've made the more general point in relation to the difficulties with advancing an argument on the basis the market is fully genericized. I'm conscious of the time, unless my lords have any questions on ground 2, that takes me to ground 3.
Oh, thank you.
Now I can take ground 3 quickly. This is all about damage to Glenmark, whether it's quantifiable under the cross undertaking. The reason I can take it more quickly is we now know that this is not a single generic entry case, but a multiple generic entry case. And my underlying submission is there's no basis in my respectful submission for a finding that the damages to Glenmark are more difficult to assess and more extensive than those to AstraZeneca. And that obviously bites both on adequacy of damage, but also on balance of convenience. Now, one point that runs through this, that the difficulties that, sorry, I'll take that, stages. The judge considered 4 matters in relation to this and respectively are the difficulties of quantifying Glenmark's losses if the counterfactual is a multiple generic entry market, and that's at judgment paragraph 92. He also deals with the duopoly, but that in my submission is no longer relevant. Loss of their first mover advantage in paragraph 94. AstraZeneca's second medical use applications at 97. Unquantifiable loss to the NHS, which I do need to deal with, which is a small but important point at 98. And there are problems in my submission with all of that. The difficulties that the judge identifies in para 93 with quantitisation in relation to multiple generics are effectively, you don't know how many, you don't know the volumes, and you don't know the prices. And just stopping there, as in the counterfactual, I would submit one sees a parity with the arguments that AstraZeneca would advance in dealing with the same problem. But nonetheless, that was then. We now don't have that same level of unknown. We now know about tether and generic X. We have good evidence in my submission that the market share that all three generics are seeking is substantial. And we have good evidence that they're going to enter very quickly. Now, this is the scenario that was run as the unfortunate position Glenmark would find themselves in if they weren't able to launch at once. And that goes back to my point at the beginning, that their primary case was all about them being the single mover. And they said it's far more difficult if we come back later and have to launch with all these other people. The simple point in here on quantification is that if at the form of order hearing there is no interim injunction, but there is an interim injunction now, the position's exactly the same. There'll be the same number of, at least the same number of generics, at least the same amount of market entry, at least the same rapidity of market entry. So in a sense, it is a sliding window. By putting an injunction in here, one is not prejudicing the position in any way at the form of order hearing, because all one has done is to move the window from one end to another. Furthermore, there is sufficient knowledge now in my submission to have a clear picture of what, if my lords were to accede to the appeal and grant an interim, one has good counterfactual evidence of who was available, who was prepared to launch, and in what size they were prepared to launch. And that makes the quantification exercise far easier than the one that the judge found. Second point is the first mover advantage, and I won't spend very long on that. The judge deals with that in judgment 92, but it is a truism in my submission to get any material first mover advantage, you need to be a first mover. There is nothing left based on where we are now. The next point I have to deal with, my lords, are the second medical use applications, and my lords, they're set out in the judgment at paragraph 97. It is correct, AstraZeneca have second medical use applications. There is no skinny label case running here on the part of Glenmark. That is also true. And the judge suggests that the inquiry is going to be more complicated under a cross undertaking because AstraZeneca may decide to reduce its liability by contending certain sales would be made by Glenmark, or effectively ones that in due course could be dealt with as infringements of the second medical use patent. Now, the short submission on this, in my respectful submission, is the point is the same in the actual or the counterfactual. There's no interim injunction, then AstraZeneca may sue for infringement, assuming that I simply don't know at the moment, but it's on the assumption that there might be a case to say that these were infringed by the second medical use patents, then AstraZeneca could sue. And there would have to be an inquiry as to damages if they won as to what the damage was. If there's an interim injunction, then the same point might be argued, but it's effectively the same point. So in my submission, the second medical use patent point is entirely neutral. It makes no difference which course this court takes. The existence of a likelihood of that action remains the same. Right, I'm on to my last point, so I will finish before the short adjournment. The NHS, so that's a point raised by the learned judge, damaged the NHS in the counterfactual at judgment 98.
Yeah.
And this is the reason why at the beginning I went to the evidence of Glenmark's Mr. Farrant to make clear the position in relation to list price and reimbursement. So in my submission, the cost to the NHS of supplying dapagliflozin, whether it is generic dapagliflozin or, sorry, the list price, the sorry, I need to make sure I don't misspeak this factually. The price paid to pharmacists by the NHS for dapagliflozin is a matter for the NHS. It reimburses, as I understand it, at the list price and will continue to do so unless and until it recategorises as either category A or category M, at which point it reimburses at the weighted average, which is set out in our scales. Obviously, the faster the market drops, the quicker the NHS may recategorise. But there is, in my submission, no unquantifiable loss here. This is just a question of when the starting gun is fired. Number one, it's within the gift of the NHS. And number two is, the judge's finding was there would be no recategorisation prior to the form of order hearing. If that is right, we will have a fact. All that has happened is the window, whether it's 1 month or 3 months, has been moved forward for the period to recategorisation. So if my lords were to grant an interim injunction now, the counterfactual would be that the market would collapse in period X. Once that is determined, that merely gets shifted along by the period before the form of order hearing. The letter that's sent by the DHSC anti-fraud office, and that's referred to in paragraph 98 of the judgment, is really about a completely different point in my respectful submission. It goes to 98. One sees that the NHS, quite rightly so, talks about the number of generics, the volume of product, so on and so forth. None of that really meets the present case when all we're talking about is the time at which the starting gun is fired. Because we know, and the reason I keep saying the starting gun is fired is because we know at least that Teva and generic X and Glenmark wish to launch now. One can infer quite clearly that Teva generic X and Glenmark will wish to launch in a month or 3 months' time after the form of order hearing. One has a good idea now of the size of their entry. One can infer the size of the entry will be the same. There's no reason to suppose that the rate of price spiral will be any different at the form of order than it is now. I suppose it could be faster. And so this point, the points that are raised by the NHS, whilst they are legitimate points and rightly raised, obviously the care of the public purse is very important, their damage is not is quantifiable because one just moves the window of time along in the quantification exercise by the period it takes to get to the form of order hearing. Can I just turn my back a second, please? On ground 4, my lord, my learned friend takes a procedural point. In my understanding, whether my lords allow ground 4 in, if sorry, my Nigerian will give me the note we wrote earlier. I've shown my lord Singh and Das. Singh and Das is about evidence, but if I can go to, just for my lord's note, to the white book. I want to amend an appellant's notice. It's governed by CPR 5217. The commentary, I don't think I need to turn it up, but it's in the white book at page 11867, says that CPR 5221 applies.
Hang on a minute, you better give us those references again. We are no longer supplied, the courts are no longer supplied with the white book, so
Grief.
As the editor-in-chief, obviously I regard that as an outrage, but there's nothing I can do about that. So we no longer have them, so you just better give us the reference.
Does my lords need copies of them which we can
have? No, mine's back in my room, and I'm sure my lords are too, but just give me the reference to the rule again, and the page.
So the rule is 5221, and 5221, in my submission, is effectively the same jurisdiction as the Singh and Das jurisdiction that I have already court.
And this is concerned with the amendment of the notice of appeal.
Yes, and my respectful submission, it is an amendment that we could not have properly brought until Stothers 4 was available. It is an amendment, my submission, that should be allowed because in my submission, these are matters which my Lordship's court ought to be able to address on appeal, all the more so if Stothers 4 is agreed to go in, which we now know that it is. My Lords, those are the submissions on behalf of AstraZeneca, unless my Lords have any further points.
Because as you made
Can you
plain,
just remind us where in the bundle we find the actual amended grounds? Because I'm struggling to lay my fingers on it. Just
I'm
for a
so
second.
sorry, my Lord.
it's a fair point.
Core tab 3, and they should be in markup on the final page, which is 22, paragraphs 5 through to 7.
Oh, thank you.
But to be clear, my Lord, I don't put that front and centre. I say that if my Lords are with me that there is an error.
That's partly because you've relied on the new evidence in support of your existing grounds.
Sorry, I'm being told to shut up, my Lord, and I will take that invitation from behind, and rightly so.
Yeah, all right.
Unless I can assist the court any further, those are the submissions of AstraZeneca.
Thank you very much, Mr. Pritchard. Mr. Abrams, do you want to have 5 minutes of fame before the short adjournment, or would you prefer to?
Really, it's a matter for your lordships. The first thing I'm going to do is going to go through the judgment, which is my best friend on this appeal, and obviously I'm not going to do that in 5 minutes. So as long as I'm not going to lose any part of my time, I think it'd be easier for the lordships if we break now and restart at 5:02.
All right. Well, we'll if it's convenient to you all, then we'll restart at 5 to 2. Right. Thank you very much.
Court rise if able.